Another important matter treated differently in Scotland is the matter of privilege and confidentiality and without prejudice statements. Looking firstly at privilege and confidentiality, court hearings in Scotland are normally held in public. Written pleadings and documentary evidence lodged are only available to the parties and to the judge. The importance of establishing that privilege exists over key documents is that it allows an organisation to maintain a degree of control over the information that is passed to their side and to the court. In Scotland, as in England, two grounds of privilege are recognised: legal advice privilege and litigation privilege. There has been very little judicial authority on privilege and confidentiality in Scotland. The law up here is far less developed than it is in England, I think perhaps as a result of the much higher volume of cases in England and Wales, and also as a result of the more onerous disclosure requirements of English litigation, which make privilege a live issue on a more frequent basis. Legal advice privilege, or legal professional privilege as it is sometimes called, is given to communications between a lawyer and a client. The purpose of the privilege is so that a client can have unrestricted confidence in his or her lawyer. The courts will only order disclosure of privileged communications between a lawyer and a client in very limited circumstances, and that is either where the client waives the privilege or where the communications concern an illegal act and a solicitor is concerned in the illegality. The types of communication to which legal advice privilege applies are those which are for the purpose of giving or receiving legal advice about what should prudently and sensibly be done in the relevant legal context. So, pure business advice is not caught by the privilege. For example, strategic or commercial advice will not be covered as it lacks the relevant legal content. Communications with third parties, for example external experts or witnesses, are not covered by legal advice privilege. They may be covered by litigation privilege, which we'll deal with in a moment. As in England, legal advice privilege is very unlikely to extend to other professionals beyond lawyers, and it does not automatically extend to communications between an in-house solicitor and his or her client. It must be shown the business employee is authorised to seek and receive legal advice. Litigation privilege is a wider type of privilege and protects confidential material that a party has made in contemplation of litigation, where the material was necessary for the sole or dominant purpose of the litigation. Privilege attaches as soon as litigation is reasonably contemplated, and up here the Scottish courts have taken a broad view as to when litigation is reasonably contemplated. This may be wider than the approach taken by the English courts. In Scotland, proceedings do not have to be commenced formally for the privilege to apply, although litigation must be a real likelihood as opposed to a mere possibility. Unlike legal advice privilege, litigation privilege extends to communications with third parties, for example external experts and witnesses. As in England, the starting point in Scotland is the court process is open. The court rolls are published daily and found on the Scottish Court's website, and they list the cases that are calling in court and in respect of which there may be hearings. Most hearings of the Court of Session, and indeed the Sheriff Court, are open to the members of the public. As in England, a wide range of judgments, including earlier decisions, can be found in court reports and are accessible using services such as Westlaw and the Lexis Library. Parties' names are anonymised only in family action involving children and in some arbitration appeals, and in certain cases when an application is made to the court under the Contempt of Court Act 1981.